Order.
Resumption of the ministerial statement by the Minister for Law and Home Affairs.
Minister Shanmugam.
So in part 2, I will go to the broader questions that I identified, which is an inquiry, or rather the questions I've dealt with in part 1 of the inquiry into how the investigations, the prosecution were conducted. Here I want to go into the broader questions. The key question is whether the case was handled differently because of the status of the complainant, or if there has been any improper influence. Really, if I were to put it this way, did LML in any way influence these proceedings, or was the case investigated and prosecuted in accordance with the rules like any other case? And I've said it earlier, and I'll reiterate. I can be categorical. There was no influence by LML. It was treated as any other theft case and handled accordingly. We have checked with the IOs, their supervisor, the DPPs, and their director. They have confirmed this. There was no pressure or influence exerted on them by LML or anyone acting on his behalf, and they handled this case as they have handled other theft cases. I'll now deal with the police. I have set out how the police handled the matter when they took into and what they took into account. It was dealt with by the IOs. Decisions were taken by them together with the immediate supervisor. Case didn't come to the attention of the senior management, either at the police or in my ministry. No one senior has spoken with or been influenced by LML or any of the LEUs on this case. Meaning, as I said, it was dealt with by the IOs and the immediate supervisor, and no one beyond that. No one lobbied or exerted pressure either on the IOs or on the supervisor or on anyone in a position to influence the investigations. Turning to AGC, I have explained how the matter was dealt with by AGC. It was dealt with by DPPs and cleared at the level of a director. Again, neither LML nor anyone acting for them approached AGC or had any contact with AGC in this case. AGC dealt with police. There have been some questions asked, specific to the Attorney General, that he was on the board of directors of Capital Land between 20th of November 2000 and 2nd of January 2006, when LML was the president and CEO. As a result, did AG in any way influence the proceedings? The answer is no. AG didn't know of these investigations or proceedings until the case went for trial. There is a further point. AG resigned from the Capital Land Board with effect from 2nd of January 2006. He resigned because he had a difference of viewpoints with LML on some issues. When AGC conducted its internal review on this matter, AG recused himself. AG felt that given the history of differences he has had with LML, the perception of fairness may be affected if AG oversaw the review. Thus, AG had nothing to do with this case at any stage. The case was conducted by the state courts in open court in accordance with the rules. This case is in fact an illustration of how the rule of law applies. A foreign domestic worker is charged, the High Court acquits her, the complainant is a wealthy, powerful person, but all are equal before the law. It doesn't matter who the parties are. Justice according to the facts and the law as the courts see it. We may agree or disagree with the state courts or high courts' decisions and conclusions, but that's a different matter. at the systemic level, if you look at it at a systemic level, at the highest level, you talk about the criminal justice system. We have the police who investigate in accordance with a legal framework for police investigations. AGC make the charging decision based on available evidence and public interest. The trial courts consider the sufficiency of the evidence and the legal issues. The appellate courts review the decision of the trial court. The case shows that the criminal justice system as a whole works. If you drill down to the next level, we have systems. For example, these would comprise investigative protocols, SOPs for how the police and the DPPs operate. I have mentioned some errors that were made. We have to try and strengthen the systems at that level, try and prevent reoccurrence. I have also mentioned the challenges. Besides these levels to the system, there will always be the risk of mistakes by individuals. These lapses will have to be dealt with. So, the rule of law, the idea of rule of law, is central to us, to our ideas of fairness, equality, and justice. It is even more important in the current zeitgeist that is sweeping through countries. Societies around the world are grappling with debates on inequality, a sense that the elite are creaming off most of the economic benefits and bending the rules and systems to their advantage, and in the process buying off, suborning those in government. People are fed up with unfair structures, equal opportunities are drying up. Singapore, we are not in the same situation. Our active intervention in socio-economic issues has helped most people to benefit. But our people know we must jealously guard the availability of equal opportunities. We must ensure that everyone has a fair shake. We must be alert, guard against the wealthy and the powerful taking unfair advantages. If a significant section of our people feel that the system favors some, or that it's unfairly stacked against them, then Singapore will lose its cohesion and it can't succeed. Thus, it is essential that we have a fair system, that we have a clean system, that we have a system that gives opportunities to all. These are our fundamental concerns. If LML did unfairly influence the proceedings, then it will be a hit to our foundations, and it will be a hit to our sense of fairness, equality, and justice, and a dent to Project Singapore itself, because Singapore is built on these ideals. We have always been jealous about guarding against such corrosion. It does not mean that there will be no abuse of power and no corruption, but when it happens, swift, decisive action must be taken. Members will know successive governments have been clear about this. There has to be a ruthless intensity in upholding integrity. Mr. Lee Kuan Yew set the tone. The case of Mr. Teh Cheang Wan is a prime example of the approach. He was one of the most senior members in Mr. Lee Kuan Yew's cabinet, but when corruption allegations surfaced, Mr. Lee directed the CPIB to conduct investigations. Mr. Teh was placed on leave of absence. He ultimately chose to end his life rather than face trial or corruption charges, which the AGC had then yet to settle. Mr. Lee said at that time, and I quote, "There is no way a minister can avoid investigations and a trial if there is evidence to support one." These were the values of our founding generation, and these are and have to be our continuing values. They have been scrupulously stressed and adhered to by the two succeeding prime ministers. They are like religious commandments. There cannot be any compromise. When there is a breach, action is taken, will be taken. Let me refer to some cases. In 2012, you had Peter Lim, Commissioner of SCDF. In fact, he was Commissioner of SCDF when I was Minister of Home Affairs too, convicted of corruption charges for receiving sexual favors with 3 different women, sentenced to 6 months imprisonment, dismissed from public service following disciplinary proceedings. 2013, you had Mr. Edwin Yeo, Assistant Director of CPIB, misappropriating money, jailed for 10 years for CBT as a public servant and forgery. In 2007, you had Mr. T.T. Durai, CEO of the National Kidney Foundation, convicted for corruption, sentenced to imprisonment, appeal to the High Court, dismissed. In 2012, you had Mr. Howard Shaw, then Executive Director of the Singapore Environment Council, convicted for obtaining commercial sex with minors, had asked for a nominal fine based on testimonials of his good character and social standing. Court found no exceptional circumstances, 12 weeks imprisonment. Sentence was to provide a strong deterrent to others. Peter Lim was a senior home team officer. In many countries, his actions would not have attracted criminal punishment. In most countries, commissioners of SEDF, assistant directors of CPIB are pretty much untouchable, but not in Singapore. The message is, doesn't matter who you are, if you do wrong, action will be taken. But it is not only corruption that we must guard against. We must also guard against what I call soft corruption and influence peddling. Let me quote what Mr. Lee Kuan Yew and Dr. Goh Keng Swee have said. In 1984, Mr. Lee said, and I quote, "We exercised power as trustees for the people with an abiding sense of our fiduciary responsibility. Our honor, our sense of duty made us exercise power scrupulously. We have curbed, restrained, prevented any distortion of policies which would have been inevitable if the personal interests of the few in charge were allowed full reign. This is the case in many new countries. When those in office regard the power vested in them as personal prerogative, they inevitably enrich themselves, promote their families, favor their friends. The fundamental structures of the modern state are eroded like the supporting beams of a house after termites have attacked them. Then the people have to pay dearly and long for the sins and crimes of their leaders." And as early as 1961, the late Dr. Goh warned about the risks that groups of elites might create an environment that would favor one community at the expense of another. In an article in Nanyang University Journal, 1961, he said, and I quote, "To achieve an honest and energetic administration appears easy in theory. In practice, very few of the young and emergent nations have achieved this. Even in the most advanced and leading societies, whether communist or democratic, the problem of nepotism is a recurring one and can only be countered by constant vigilance. In advanced societies, it's not so much open nepotism that is to be feared, but the insidious old boy type, whereby no illegalities are committed, but in which the pinnacles of power, influence, and wealth are the reserve of those born into the right families. In underdeveloped countries, the matter could be more serious. A system may arise in which the dominant majority, whether of families, clans, or even entire communities, arrogates to itself not only the openings to the seats of power, but also the avenues by which individuals can fit themselves out for such positions of power. The dominant majority is thus able to point out that those outside of the charmed circle just do not have the necessary qualifications to be admitted to this elite group. Thus, many able and aspiring people are denied the opportunity for the full use of their abilities. I personally find these words very powerful, insightful, and have more than once quoted this speech of Dr. Goh in my own speeches, because Dr. Goh, I think, has identified precisely a serious, insidious risk in any society, including ours. We are not that special that we can be immune to these risks. We have to constantly make sure that we don't allow it. We have to be very careful to try and stamp it out wherever it appears, and make no mistake. Make no mistake. It will keep appearing in big and small ways. This is again something successive prime ministers have been vigilant about. One illustration of that is the letter that the prime minister sends out at the start of each new term of the House. Most members are aware of the letter. I've put it in Annex 8. I think you all will have the annexes by now. I quote parts. The context each time may be different, but the subject remains constant. Integrity, honesty, and incorruptibility are fundamental. We must never tire of reminding ourselves of their importance. One vital factor to retain the trust of Singaporeans all these years is honesty and integrity. The reputation for clean, incorruptible government is one of our most precious assets. I cannot stress strongly enough, every MP must uphold the rigorous standards we have set for ourselves, do nothing to compromise them, never give cause for allegations that you're misusing your position, especially your access to ministers. A few will cultivate you to obtain benefits for themselves or their companies, to gain respectability by association with you, or to get you to influence ministries and statutory boards, to make decisions in their favor. Personal favors, big and small, are just some of the countless social lubricants which such people use to ingratiate themselves to MPs and make you obliged to them. At all times, be seen to be beyond the influence of gifts or favors. Separate your public political position from your private, professional, or business interests. MPs who are in business, who occupy senior management positions in companies, or who sit on company boards should be especially vigilant. You must not exploit your public position as government MPs, your close contacts with the ministers, or your access to government departments and civil servants for your personal interest or the benefit of your employers. Your conduct must be always above board. We have held our position because our integrity has never been in doubt. Always conduct yourselves with modesty, decorum, dignity. I can tell members this. This is all not just nice sounding advice. Even before it reaches the kind of conduct referred to in PM's letter, if we feel that there is some conduct that requires a closer look, we do take a closer look. I am referring here to conduct which is not criminal, not a breach of ethics, but which in our view should be avoided. Something that may be legal, but for example, lead eventually to something which is not of so good order. When we sense that, I usually have a chat with a relevant MP. They come, have a cup of coffee with me. When they leave, the issue is usually resolved. And if it is not resolved, then they don't remain as MPs. But don't worry, it doesn't happen every time people come and have coffee with me. Yeah. If it is criminal, of course, there will be prosecution, and there have been MPs and ex-MPs who have been prosecuted. And if there are breaches of other rules, the respective professional or regulatory bodies will take action, as they have done. We don't intervene or try and stop any of this. I have dealt with this at some length because we must understand these are fundamental values, and if we don't keep them, we will be in trouble. And in Singapore, in this context, we have a more challenging environment because we are a small place. A lot of people know each other. Many educational, professional, work-related, social, family connections. Same schools, colleges, universities, time spent in national service, other connections, people interact with each other frequently. We try and look for people on the basis of merit, and they will often, because of their careers and education, have deep connection with many others whom they interact with. The way we handle this, make sure the persons appointed are men and women of character. They have the moral fiber to do the right thing. Earlier I had said the Attorney General recused himself from the review because of his history with LML. What will the position be if he was in fact a close friend of LML? We will expect him to disclose that and recuse himself as well from any decision making. This is how the system works. Let me give a few examples. Professor Jayakumar, when he was Minister for Law, what were his connections? When he was Dean Law School, the then AG's wife had been his vice dean. Former Chief Justice Chan Sek-Keong had been his law school contemporary. Former Commissioner of Police Goh Yong Hong was also his law school contemporary. And the succeeding Commissioner of Police, T2 Abba, was Prof. Jaya's law student. The Attorney General and I were his law students as well. I had spent 22 years in private practice. I have worked with many senior counsel, senior lawyers, appeared before many judges. Our small size means these connections, interactions are inevitable. And so we will always have to be very careful. Always remember we are fiduciaries. This is a sacred trust. We do this for the people. We do the right thing. Do not allow any corrosion of public interest. Act with honor. Be worthy of the trust people have reposed in us. It is critical that whatever the relationship, the government maintains high standards of probity, of conduct, so that decisions are made on objective and impartial assessment. And have we lived up to those standards? Members can ask that question honestly. What is the lived reality for Singaporeans? How much corruption do people encounter here? We rank highly on credible international indices for absence of corruption, for rule of law, for the way our system functions cleanly. This is a country known for all this, and that continues to be the case. What happens if you allow the system to go awry? What happens when you allow influence peddling? What happens when you allow corruption, abuse of position, abuse of power? Let me just give you a couple of examples. First, the US. Influence peddling has become part and parcel of politics and governance. The US Supreme Court has said, ingratiation and access embody a central feature of democracy, not against the law for officials to set up meetings, host events, call other officials on behalf of lobbyists. Big businesses extensively lobby regulators using middlemen. I personally think this is not good for the healthy functioning of society. Lobbying itself in the US is massive business. Big Pharma, for example, spent US $4.45 billion on lobbying alone over the last 22 years. And it works. One study found that regulators were 45% less likely to initiate enforcement action against banks that lobby versus banks that don't. The experience of South Africa offers another example. In South Africa, state capture is a buzzword because of how private interests have exerted influence over government decision-making and used this influence to plunder the state. Corruption scandals involving the former president and the Gupta brothers are the most famous examples. It is, of course, an extreme example of the system going awry. Critical question for us, how do we ensure that the system stays clean, that we don't allow what Mr. Lee and Dr. Goh warned against? We have a media that highlights these issues. See the number of articles that have appeared in this matter in the Singapore media. Accountability, because a well-educated, aware population that holds us accountable, and Parliament, where we have these issues to be openly discussed, debated. All these are essential. But these factors are also present in many countries where influence peddling is nevertheless a cancer. We have avoided that slippery path because, in addition to the above, we have had in our three prime ministers the strong will to ensure a clean system and the decisiveness to act when something goes wrong. In always, regardless of your rules and regardless of your systems, the rot starts at the top. If the top is clean, then your systems can work well. And we've got to make sure of that. And if it starts, then very few things can save such a country. In this case, if we had seen anything wrong by way of influence peddling, swift, open, transparent action would have been taken. So, I have spoken at some length on the case and on the broader issues. Now I will deal with the questions members have raised by way of PQs, which I have not already dealt with. Mr. Pillay, Murali Pillay, Dr. Tan Wu Ming, Mr. Vikram Nair, Mr. Liang Eng Hua, Mr. Derek Goh have asked a number of questions about the High Court's observations, the agency's processes, the internal reviews, and related questions. Part 1 of my statement has covered these points. Dr. Tan and Mr. Goh have also asked for some information on foreign domestic workers, theft cases, court proceedings. I have said earlier, police investigate around 14,000 In fact, 14,122 theft-related cases. I think that was in 2016. For the specific offense of theft as a servant, an average of 528 arrests annually. About 48% of them are foreign domestic workers. On average, about 70 or 27% of the 255 foreign domestic workers were prosecuted. We do not track data on how many of them claimed trial or how many of them had legal representation. At the same time, the reverse side of the coin, employees from 2015 to 2019, 115 employers were prosecuted for committing offenses against foreign domestic workers. This includes cases of physical and sexual abuse. 65 persons have been convicted, 21 cases are pending. Mr. Louis Ng asked if foreign domestic workers and other work permit holders can be accompanied by non-legal personnel similar to the appropriate adult scheme for police interviews. From 2015 to 2019, an average of 2,741 foreign workers on work permits were arrested each year as potential accused. Interviews have to be done quickly. I've earlier said police are already very stretched. Really, let's not stretch them further. It will be a very difficult exercise. Appropriate adults attended to 2,300 activations in 2019. These cases involved minors and mentally vulnerable persons. If we have to provide AAs for every foreign worker interviewed, we would have to minimally double the current volunteer pool, provide the training and resourcing, and some may require more than one statement, and this will become a real constraint and load on the police. And each time you have an interview, you have to look for an appropriate adult. Interviews will be delayed if the AA is not available. Evidence could go missing. There are other issues. The foreign workers are adults. The key is for police to make sure that the foreign workers understand the questions and their answers are properly recorded. And it has to be open for scrutiny in court, which it is. So that members can understand the load on our officers, I'll share the following. As I said earlier, police investigated 66,200 criminal cases in 2016, and they were handled by 1,100 IOs. Just to give members a sense, the ratio of police officers, and I've spoken about this previously in the House, and I'm here referring to police officers in general, not just IOs. New York at 0.42%, London at 0.34%, Hong Kong at 0.39%, Singapore at 0.23%, including full-time national servicemen. If we were to have the same numbers as Hong Kong, we will need 9,100 more officers. My entire police force today comprises 13,200 police officers, including national servicemen. If we were to have the same numbers as Hong Kong, we would have to have 9,000 more officers. If we have to have the same numbers as London, we will need 6,000 more officers. If we were to have the same numbers as New York, we will need 11,000 more officers. So members can understand and appreciate the load on our officers. And as I said, I've spoken about this in the House more than once. And my concern is that there is a limit to how much our officers can do with increasing workload and increasing expectations, but without a proportionate increase in manpower. Mr. Lim Biao Chan asked how many state court judges have previously worked as prosecutors in the AGC, and whether the ministry will review the policy of separation of duties. This point has come up previously, and let me put it this way. The total number of lawyers in our legal service and judiciary, excluding high court judges, is 801. That is a relatively small number. In this context, the question is, why are officers posted between the state court and other parts, posted between the state court and other parts of the legal service? Can there be independence if they are liable to be cross-posted? Let me quote something quite dated. Mr. A.P. Raja, former Speaker, High Court judge, said in 1963, he thinks that if you're a DPP, then you cannot be a good district judge. If you're a district judge, then you cannot be a good DPP. If you're a first-rate DPP, then you cannot make a first-rate SI's judge. He seems to suffer from that misapprehension, merely to say that because one has been a DPP, and that therefore when he gets onto the bench, he's going to side with the prosecution, is not correct and is not fair to the profession. I'm not suggesting that Mr. Lim or anyone else is under any misapprehension. I think it's a fair question. And this was said in 1963 when the number of officers was much smaller. What is the situation now? Today, all movements in the legal service are overseen by personnel boards and or committees, all chaired by the Chief Justice and the Legal Service Commission, of which the Chief Justice is the President. The Legal Service Commission takes the view that rotation has three major benefits. One, it provides access to a larger pool of talent to select state court judges with the right blend of temperament and knowledge and experience. Two, it develops LSOs into well-rounded officers by exposing them to and training them in different fields of legal work and allowing them to learn about their strengths and weaknesses, and this benefits the legal service and Singapore no matter where the LSOs are posted in future. Three, this also gives flexibility, for instance, to accommodate LSOs who want to try different types of work, or LSOs who have a change of heart about their preferred line of work. Judges who have prosecutorial experience will bring added knowledge to the work. However, significant changes have also been made. In 2014, PM announced greater specialization in the legal service. There are now two separate career tracks for the middle rank of LSOs. One is the legal track, and the other is the judicial track. LSOs on the judicial track are posted to jobs within the judicial branch, and they are assessed by a separate judicial branch special personnel board headed by the Chief Justice. PM explained why this was done. We need a first-class legal service that in turn calls for a first-class personnel management system to attract and retain the best people, to remunerate them fairly with reference to the market, to groom talent systematically and prepare them for leadership positions, and to imbue officers with the right values and commitment to Singapore. Up to now, we have always decided to stick to the integrated model because we had too few officers to support two separate services, and we believed that LSOs would have a better career path in one single integrated service. But it is timely for us to review the position again in the light of changing circumstances. First, because the legal service is much larger, so officers can specialize without conscribing their career prospects. Second, because the scope and complexity of work, whether in government ministries, whether in AGC or in the courts, the scope of work has in all cases grown enormously in the government, in the ministries. There are more responsibilities. Hence, we need more specialist and expert skills than ever before. Thus, LSE introduced two separate career tracks for LSOs up to grade 3, the legal and judicial tracks. Eligible officers can elect to specialize along either track. They will then be posted to jobs within either the legal branch or the judicial branch. To oversee the two career tracks, two new personnel boards under the LSE, the legal branch personnel board, and the judicial branch personnel board was established. These boards manage the LSOs in the respective branches. However, even as we promote more specialization, it is critical that the legal service operates as an integrated whole. The specialization into the two tracks is for the middle ranks of the legal service. Junior officers starting out in their careers will still be posted to different departments and across branches to develop them in the different fields of legal work. Beyond grade 3, the senior officers at grade 2 and above will still be managed by the Legal Service Commission, because at that level of seniority, there will only be very few officers, and it's necessary to continue with the integrated model to provide better career options and flexibility in deployment to meet the needs of the service. The approach we have adopted strikes a balance between the specialization and integration with safeguards for judicial independence. The system is working well, and we think that this is what is good for Singapore. Now, Mr. Leong Mun Wai has asked whether there can be an expedited trial process for foreign, economically vulnerable accused persons. And he has also asked about the interpretation services in SPF. First, on the trial processes, the median time taken in courts for a criminal case from being first charged in court to judgment is 15 months, median. Right? Depends on the nature of the case, availability of counsel, DPPs, how long the trial itself takes, documents, witnesses, challenges that the prosecution and defense make, and time taken for deliberation. State courts, as I said earlier, handle about 600 criminal trials per year. We have 55 judges to handle these trials. Again, it's a very heavy load for the state courts. About a quarter, 22% of these cases involved foreigners. If we expedite a case for a foreign person, then a Singaporean accused will have to wait even longer if we take Mr. Leong's suggestion. So having a criminal case pending, why should we make Singaporeans suffer disproportionately more? If I can give one example, we had a 51-year-old Singaporean accused person charged in March of this year for 2 counts of shop theft. He claimed trial to the charges against him and was remanded. In June of 2020, AGC assessed that his remand period, 3 months at that point, might outstrip his possible sentence even if he were to be convicted. At the public prosecutor's request, the trial was brought forward and conducted on an urgent basis. A 2-day trial was conducted, after which he was convicted and sentenced to 16 weeks of jail. There will be many other cases like this, but even if there is no specific remand situation, if you bring forward some people in the queue, the others in the queue will have to wait longer. Right? And I don't think it is fair to Singaporeans to do what Mr. Leong has suggested. Second, on the interpretation service, I've given a fairly extensive answer. The police currently employ a pool of interpreters for the 3 official working languages, Chinese, Malay, Tamil, as well as more common local dialects, Hokkien, Teochew, Cantonese. The police will engage the services of interpreters if the interviewee is unable to understand the language used by the interviewer, or vice versa. For foreign languages, the police will engage the services of foreign language interpreters or on an ad hoc basis. There is a framework to assess the suitability of interpreters, which includes their qualifications and relevant work experience. As regards Ms. Liyani in this case, she was asked, she said she could speak in Malay. The point is, does the interviewee understand the language being used? And as I said earlier, the police have been told they must really check this. Mr. Zulkarnain and Mr. Leong Mun Wai have asked about increasing legal aid for accused in criminal cases. And secondly, increasing the honoraria paid for lawyers under class. Ms. Carrie Tan has also specifically asked if we will consider having a public defender scheme to defend accused persons in criminal cases. Let me give members background to the criminal legal aid scheme or CLAS. CLAS aims to provide legal aid to persons facing non-capital charges. It's administered by the Law Society's Pro Bono Service. This scheme was started in 1985. The initiative came from the Law Society, senior lawyers, in particular the late Mr. Harry Elias, and it was an outstanding initiative by the profession. There is in place a framework, an assessment process, means and merit tests applied in each case to try and ensure that funding is targeted, allocated to applicants who are most vulnerable and who genuinely need assistance. The government pays 75% of CLAS's operating costs. This goes towards general operating costs, including staff salaries and overheads. This was decided in 2014. I announced it, and it started from 2015. Where the accused are Singapore citizens, PRs, the money can also be used to pay honorarium. Class funds the remaining 25% of its costs through private donations. Law Society pays some, and this sum is also used to defend foreigners who need criminal legal aid. But I should make clear, I referred to honorarium. The honorarium that is paid is extremely nominal. It's effectively pro bono. Right? It is a system where the government funds some part, the private sector funds some part through cash donations, lawyers giving their time. Should we change this model and go for full government-funded criminal legal aid? Let me first give members a sense of the experience of other countries. I'll just give the experience of 2 countries. Though we have many experiences, we can look at many countries' experiences. The United Kingdom offers or at least England and Wales offer a fully government-funded criminal legal aid scheme, which comprises both a public defender scheme with in-house government lawyers and a legal aid scheme that outsources cases to private lawyers. There has been much public debate and outcry in the UK over these schemes for various reasons, including abuse and escalating government costs. First, there's been much unhappiness over the large legal aid fees, especially evident in cases where legal aid was spent on lengthy trials for defendants who are ultimately convicted. For example, 3 men who were accused of the murder of a policeman known as Andrew Harper. When they tried to evade arrest, he tried arresting them, they killed him, cost the UK taxpayer, in Singapore dollar terms, $817,000 in legal aid fees in the year 2008, and they were convicted of manslaughter in the end. Another case was that of Ben Butler and his partner, Jenny Gray, who were convicted of murdering Butler's 6-year-old daughter and of child cruelty. Both were granted nearly $2.64 million in legal aid and expenses, covering both their criminal cases and a custody battle with the child's grandparents. There have been many reports about rich defendants who received legal aid as their assets were frozen, but they remained wealthy enough as the state did not manage to seize all their assets. Around 50 defendants with more than $1.76 million in illegally obtained assets were found to have received legal aid in the year 2012. One of these was Virendra Rastogi, a London metals trading tycoon, who owned a $10.55 million pound home, arrived in court every day in a chauffeur-driven car, and he received $8.79 million worth of criminal legal aid. These defendants were ordered to repay their legal aid costs, but some failed to pay up despite court demands. Given the large legal aid costs, it has been difficult for the UK government to sustain this level of spending. The government has had to implement drastic cuts to legal aid budgets since 2012. But these reforms were strongly opposed by the legal industry. Lawyers deemed the reformed fee schedules to be inadequate, went on strikes in 2014 and again in 2018 to oppose cuts, disrupting court proceedings, delaying the resolution of criminal cases. In one case, a convicted drug dealer was allowed to keep his alleged $7.9 million fortune because of delays in finding a legal aid lawyer to represent him in confiscation hearings. The lawyers' protests eventually resulted in more watered-down reforms, continued escalating legal aid costs for the government, and legal aid lawyers won a $40 million fee rise after the 2018 strike. You must note, once you make legal aid a requirement, then you cannot proceed with the case until you find a lawyer who is willing to handle it for the fees that he proposes. If we take Ms. Liyani's case as an example, the Defense Counsel has estimated that if full fees were charged, it could have cost about $150,000. If we make criminal legal aid a requirement, then the taxpayers will have to pay that amount or whatever the Defense Counsel requires. It could be more, it could be less, or have the trial postponed until a lawyer is found. This is what is happening elsewhere. So I welcome suggestions, but members, please look at these points. And then when you make your points, maybe offer concrete suggestions on how we can avoid what has happened elsewhere, if we want to go down this route. My second example is Hong Kong. Hong Kong is a fully government-funded public defender scheme that outsources part of its cases to private lawyers and the Law Society. Hong Kong spends a total of $217 million on both civil and criminal legal aid spent in 2017. Hong Kong has also experienced escalating legal aid budgets due to continued increase in lawyers' fees of around 4 to 10% every year. This is why we have been very careful. We also looked at the situation in Australia, New Zealand, raised similar issues. I will not go into them, but we knew it can get very costly and very difficult to manage. So in our situation, we have actually been very fortunate because our legal profession has worked with the Law Society, the government. We have got class. It's been a cooperative relationship and a strong public spirit. We make Singapore a vibrant legal center. It means our lawyers do well in the other areas, and we are able to encourage the pro bono spirit at the same time. Mr. Leong has asked, can we increase the honoraria that is paid to lawyers under class? My preference is to keep the pro bono spirit, a mix of lawyers employed specifically by class, small number, lawyers from private sector coming in, I think is a better approach. So our approach has been legal aid for those who truly need it with public-private partnership, tapping on the excellent pro bono spirit of our lawyers, and should we give it up? But I will say this, we are also not completely satisfied with the current model. There are some hard questions. How can we better help those who can't pay for lawyers and yet make sure that we don't go down the road that other countries have traveled? Last year, we reached the 5-year mark since the enhanced class was announced in 2014. As I said earlier, class was originally initiated in 1985 by the late Mr. Harry Elias, together with a group of lawyers, to better help those who could not pay for a lawyer. In 2015, pursuant to my announcement in 2014, we enhanced class with the support of the legal profession, and we started reviewing the enhanced model last year, which is the 5-year mark since we made the first announcement. We considered different possibilities. We have been considering different possibilities, including possibly a public defender's office. Class today covers the lowest 25% in terms of household income. Should we expand that number? I'm happy to hear from members. We will consider suggestions seriously. I should also mention that in 2014, when we announced the enhanced class, some in the legal profession were very concerned that this was going to eat into their rice bowl. There was some disquiet. We received a petition from some lawyers about not that few, about the possible adverse effect of enhanced class on their work, on their livelihoods. Then SMS Indrani and I met some of these concerned members from the criminal bar in 2014. We showed them the figures, that we were not going to take away their work, that we were helping those who could not have gone to them anyway. People need to be helped, and that is central to government's mission. Our profession has 781 firms who are between 1 to 5 lawyers in the firm. Of these 781, 233 firms practice criminal law. In terms of lawyers, that's about 750 lawyers who practice criminal law. Many depend heavily on the smaller value legal work on criminal cases. We should aim to have a structure that helps those who truly need help, but doesn't become an unacceptable strain on the Treasury. And those who can afford to pay for lawyers, the taxpayer should not have to pay for them. So in this context, the Public Defender's Office assisting together with the means and merits test seems like a good option. Law Society is in principle supportive of expanding criminal legal aid in order to enhance access to justice. However, the Law Council has expressed strong concerns on the impact on paid work, especially for small firms. They had doubts as to whether this proposed expansion that the government has been discussing with them would so neatly capture Singaporeans who couldn't afford lawyers' fees. The criminal bar reps have come to propose to expand the coverage of offences rather than increase the means test coverage. We will continue discussions and decide. The primary factor will be, as I have said, to ensure that those who can't afford lawyers can get access to justice without the situation becoming fiscally difficult for the taxpayer. And the government, we are discussing, but is in principle, prefers the approach of a public defender's office. So the answer to Ms. Carrie Tan's questions is yes, we are considering seriously a public defender's office. We will study the details and feasibility of this further in consultation with Law Society and the criminal bar. I've used the term public defender's office assuming that everyone understands what it means. Maybe I should explain. Public defender's office means the government pays for the lawyers, employs the lawyers in a separate structure, and they act in criminal cases to defend accused with a suitable means test and with a suitable merits test, obviously. How many officers, how big, how much conversations we have to have with Ministry of Finance, amongst others. But in principle, we'll have to first discuss it with the profession and then talk to MOF and deal with the issue. But in principle, our approach, I think, might have to go down that route. And we are, at least my ministry, Ministry of Law, is in favor of this approach. Now, finally, a committee of inquiry. Mr. Leong has asked for a committee of inquiry to consider the conduct of police and AGC in relation to Ms. Liyani's case. I assume his concern is whether there was any undue influence by or on behalf of the Lius on police or AGC in this matter. So, Committee of Inquiries under Section 9 of the Inquiries Act, it sets out the list of purposes for which a committee of inquiry may be appointed. Accidents involving death, serious injuries, serious property damage, incidents that may endanger public safety or public health, conduct of a ministry, department, statutory body, falling under the responsibility of the minister, conduct of any officer employed by such ministry, department, or statutory body. I think it will be clear to Mr. Leong, if he had looked at Section 9, that I don't have the power to appoint a committee of inquiry in respect of AGC, because it is not an agency that reports to me. Now that I've shown the member this, I think he will acknowledge his request is legally not doable. Let me make a set of broader points. If member really wants another inquiry into this matter, then what will be necessary is a commission of inquiry, not a committee of inquiry. That is very high level, headed by a Supreme Court judge or someone qualified to be a Supreme Court judge. I am prepared to recommend to Cabinet that we have a commission of inquiry. But member should first tell us what he wants this commission of inquiry to look into. And he should confirm that he will come to the commission of inquiry and state his position. I say this for the following reasons. The officers involved, both AGC and police, have confirmed categorically no improper pressure. This Liyani case was dealt with as a routine case. I have set out the facts, what has happened. It shows clearly there was a good prima facie case to proceed. There is also the disciplinary tribunal which will inquire into the complaint against the AGC officers. Thus, before we have a commission of inquiry, which is a serious matter, will take up resources, lots of time, more and more work, members should specify what part of this matter continues to reasonably make him believe and question that undue influence was used by the Lius. What exactly, by reference to what the police did and what AGC did, I would like him to tell us, sir, before I carry on.
Mr. Leong.
To answer the minister, okay, first of all, I'm aware there's a difference between committee of inquiry and commission of inquiry. The reason why I raised the question is actually to try to first establish a principle. Do we all agree that there's a need to have an independent inquiry into this case? Secondly, as to why I think it is still important to have an independent inquiry is that the more I heard or listened to the animated presentation and speech or statement by the minister, the more I found that there are a lot of information regarding the case that could be further investigated and further interpreted and come out with a more informed judgment of the whole situation. Of course, the minister had provided a lot more information today, which I fully appreciated. I didn't have those information when I raised this question and proposition, but still, after listening to the minister, I think that there's a need, still a need to have an independent inquiry, and as to what form it takes, I think the minister has explained, maybe we have to go to the level of the commission of inquiry. Okay. So I think Singaporeans are expecting that we do further investigation into this case, not just about the inference of the inference peddling, also about the systemic aspect of the whole criminal justice system that maybe we need to look at various aspects, which actually the minister have enlightened us tremendously today. Okay, on the for example, the evidence gathering, and also the when the court refers to the thing, is like I'm not a lawyer by legal training, but I was told by lawyers that it could be called evidence condemnation and all those things. So, and then also about how the AGC had made the decision, and also about the need to whether there's a need to have a public defender office and all that. So all these things I thought is very enlightening, but I think it requires more discussion so that we can come up with a better system. It is not just the inference peddling that we are talking about here. I hope that answers the question, Minister. Thank you, Speaker.
Quite. I mean, first let's settle this. I don't understand why, if you knew that difference between committee of inquiry and commission of inquiry, you have asked me to do something that's not possible. Doesn't make any sense. But let's move on. All I want to know, Public Defender's Office, for example, the Commission of Inquiry will have nothing to do with that. It's a policy statement. So, Mr. Leong, can I ask you, Commission of Inquiry is a serious business. We are not shying away from it. I'm prepared to recommend it. That's not the issue. But it's not a question of making some broad and vague statements. You are a representative of the people. We take it seriously. This is serious business. It's not a question of saying, I'm not a lawyer. Lawyers say something about condemnation of evidence. I have set out in the House what has happened. I would expect you to be able to tell me, based on what you have heard, which part leaves you concerned with either the influence peddling issue or any other issue. I mean, what? We have a commission of inquiry on the entire law, legal police and enforcement system? Is that even imaginable? So, can we please have some clarity on what is it that concerns you? What aspect? I assume you have read the judgment. I assume you have read the key material. I assume you knew that there was something specific or a set of specific issues that you want to focus on, which is why you asked. So what are those issues? What is it that you want the Commission of Inquiry to look into, which has gone wrong? Is it the translation issue? I've told you what happened with the translation. Is it the fact that they took 5 weeks, the police, to go and look for the items? I told you what has happened. And I told you there are disciplinary proceedings against the officer. So what is it that exactly that you're looking for? And I'll be prepared to recommend to Cabinet to hold a Commission of Inquiry.
Mr. Leong, please be specific in your responses.
Okay. Okay, Minister, I think one issue, for example, after listening to your statement, specifically, I was thinking, like, for example, you mentioned about the police having taken 5 weeks to attend to the evidence, and then you say that, there's some lapses, but nevertheless, the manpower situation is very tight. I think that's my interpretation. I may be wrong. Huh? So to me is that even if the manpower situation is tight, do they need 5 weeks to attend to the evidence, for example? So I'm quoting this as an example because I think there are many aspects, as I say just now, that need further investigation so that we can come up with a whole integrated and overall systemic look at the whole systemic aspects of the criminal justice process so that we can come up with a better solution. That's the reason why I have recommended that we have an independent inquiry. Thanks.
Mr. Leong, if it is the 5 weeks, I told you, I said to the House, there is no excuse for the 5 weeks. I said there is no excuse, but I asked for an explanation. The police do not in any way seek to defend it, but we gave an explanation. I said there are manpower issues, but that's not an excuse. And the officer is facing disciplinary proceedings. So what is it about the 5 weeks that concerns you? Is it that he was unfairly influenced? Is it something else? I mean, he shouldn't have taken that length of time. He will be disciplined. His reasonings will be gone into, and he'll be dealt with. If it is a 5 weeks, I'm not prepared to recommend a commission of inquiry for that purpose, because the question you ask doesn't make sense to me. Is there any other issue that you are concerned about?
Okay, if Minister, thank you for your question. If that is the case for the 5 weeks, then we take it as that. For the another aspect, for example, you have been talking about you have been trying to interpret LML's behavior and his family's behavior, for example. That interpretation could also be further sort of investigated and analyzed. Okay? For example, in terms of the maid's behavior, it is quite, for example, it is quite common that when we have the maid at home, we do actually have some leeway for her to do certain things, okay? To the extent that sometimes he takes something, you know,
Mr. Leong, we can call an inquiry into any issue. So what specifically, you have been asked, what specific issues do you have that warrants asking for this commission?
May I intervene?
Please do.
Okay.
Mr. Leong,
Yes.
I've said there are 250,000 foreign domestic workers and about 200,000 families. How they interact with each other cannot be the subject of a government commission of inquiry. The government commission of inquiry has got to look at government institutions and organs. I have talked about the motive issue. I've explained why. It's not to cast doubt on anything, but to say we had to investigate because the High Court made some observations. As a result, we made the investigation. Now I have the information in my hand. I have no choice, but in duty of frankness, I've got to put it to this House. But I explained what was the evidence that AGC and police had, and whether members felt prima facie, that was, so that members understood what was the prima facie evidence that police and AGC had. It is legally not possible to hold a commission of inquiry to look into the conduct of employers and maids. That's not the business of commissions of inquiry.
Yes, Minister, I understand that. But at the same time, you have an interpretation of the motive, okay? And you have the benefit of having new information.
No, the interpretation of motive has got nothing to do with the government organs. I just explained why that was put forward. It's got nothing to do with how the police proceeded. It's got nothing to do with how AGC proceeded. It is something that has come out in the course of the investigations, subsequent investigations. How is that a subject matter of a commission of inquiry?
Yeah, but then when there's new information, okay, coupled with the information that came out of the court process, don't we have to get to the bottom of it? You have provided one interpretation.
High Court has acquitted Ms. Liyani. That's final. This House is now dealing with whether there was any improper influence exerted on AGC or police. I've given you the facts. I've given you categorical confirmations as to at which level this was handled. I've also said, as a result of the High Court's comments, the investigations, some facts came out, which we are disclosing to you. I've also said later this evening, an announcement will be made as to what are the next steps to be taken as a result of those investigations. I am not prepared to recommend a commission of inquiry to look into this issue of motive. It cannot properly be the object of a commission of inquiry.
Okay, Minister, I think what I'm trying to drive at is that the whole case probably requires more investigation, okay, and interpretation of the facts. So, but if you think that that is enough, then I will withdraw my proposition or recommendation for an independent inquiry. Thank you.
I have to say, Mr. Leong, it is not right to come here and say, I think that a commission of inquiry is necessary. I cannot tell you why. I cannot tell you what my concerns are. I cannot pinpoint anything. I make no allegations. But in general, it's good to have a commission of inquiry. Commissions of inquiry don't proceed that way. Let me put it on record. I have no problem recommending such a commission of inquiry. Obviously, I'm not saying this without having consulted with my cabinet colleagues. Cabinet will be prepared to recommend a commission of inquiry. We have nothing to hide. We're completely transparent about this issue. But it's not, in law, they will say, macabreism. It's not because something strikes your mind and suddenly you get this idea that we have commissions of inquiry. You have had several weeks now since the High Court judgment. If there is something specific, put it down. We will hold a commission of inquiry. So far, I've heard nothing.
Okay, thank you, Minister.
Mr. Pritam Singh wants to. Yes.
Would you like to address, Mr. Pritam Singh?
Pardon? Not quite. I thought you wanted to take part in the... I'm always happy to hear from you, Mr. Singh. Sir, I had intended to say that I'm prepared to recommend to Cabinet to hold a commission of inquiry if the member stands by his views, despite what he has heard today, and provided he will come to the commission and repeat those allegations. But so far we have heard nothing that I can rationally put together to justify a commission of inquiry. So I will leave it at that. I think I've answered all the members' questions.